You went into business with someone you trusted. Maybe it was your cousin, maybe it was a friend from secondary school, or maybe it was someone from your family who came to you with an idea and then you thought, this person would never do me wrong. So you said yes, you pulled money together, and then you started making plans, and then you started actually building that business. All this time, you did not put anything down in writing because this was not that kind of a relationship where you pull down a piece of paper and then you tell someone to sign before you trust them. This is a solid relationship. You guys are family, you guys are strong friends. So you don't think anything might happen. Then something went wrong. Maybe they started making decisions without you. Maybe the money wasn't adding up and the explanations were not making any sense. Maybe you showed up one day and then you realized something that you helped build, you were being pushed out of. And now you're sitting there with this feeling that's so hard to name. It's not only anger, but it's also embarrassment. It's that voice in your head that's asking you constantly, how did you not see this coming? And it's also that fear that because nothing was written down, you think that you don't have any ground to stand on. I want to talk to you today, specifically you, because this is one of the most common situations I hear about, and also one of the most painful, because it's not just about the money, it's also what it does to a relationship and your confidence in making your own judgments. And the first thing I want you to know is this: the fact that you trusted someone does not mean that you're naive. Trust is not the problem. The problem is that trust and legal protection are two separate things. And nobody teaches you that. Nobody sits you down and says, listen, you can love someone and still have a contract with them. In fact, I would argue that the people you are closest to sometimes are the ones that you most need a contract with, because those are the relationships that boundaries are most likely not spoken out loud. There is a very blurry line of boundaries between you two. So let's talk about what the law actually says, because most people think just because there was no written document that means I don't have any right and there is no case, but that's actually not true. In Tanzania, there is a specific law that talks about contracts and it's so clear. It's called the Law of Contract Act. And basically, an agreement doesn't have to be in writing to be legally binding. What it needs is free consent between people who are competent to a contract with the lawful purpose, exchanging something of value. So if you haven't been forced to entering into a contract or an agreement, there hasn't been any force or any blackmail, that contract is valid. If you're both above 18 years old, you're not restricted by the law to enter into any agreements, and your judgment is not impaired by any sort of sickness, then that contract is valid. If it's a lawful purpose, like you want to do a legal business that's going on in the country, and also if there is something of value being exchanged, so let's say services for money or products for money, all that is legal, that is a legally binding contract. And that's it. If two people or three or four have agreed to do business together, if they've agreed on what to contribute, each person will contribute, and they've also agreed how to share anything that's being produced by that business, then that's a contract. The fact that it happened over a phone call or across a dinner table where there was no paper in sight does not mean that that contract doesn't exist. It doesn't make it disappear. The law also says that every partner is obliged to perform their promises. If any of them breaches that agreement, then the other person is entitled to compensation for the loss that he or she faced as a result of that breach. So let's say in your case, the agreement exists. Let's say it was an oral agreement, nothing was written down. The law does protect you from such an agreement, but the problem is proving it. Let's say you're in a position where you would like to get compensated for a breach. How do you prove to anyone that that agreement even existed? And this is where I want to tell you about a real case that happened in the country, because sometimes you need to hear that courts have already dealt with a similar situation as yours to realize that your situation is also equally important. In 1998, two men entered into an oral agreement to start a business that was a restaurant bar. They agreed to start this business together. One of them even contributed physical assets to the business, like empty beer bottles, empty crates, and all of this happened orally. Nothing was written down, no contract was signed, and they started doing that business. A year later, in 1999, one of the partners pushed the other one out. Their names were Anselim and David. So Anselim claims that David pushed him out of the business and even accused him falsely of theft as a strategy to push him out of the business. And because Anselim was hurt by this decision or these actions, he went and opened a case at the district court. Anselim went to the district court because he wanted compensation for, first of all, breach of contract on David's part, but he did not succeed. He did not win in the district court because he failed to prove that the contract existed. He did not produce any witnesses to say that we saw them, we were there when they were making this decision, and there was a contract that existed between them. Obviously, he wasn't satisfied by this decision, so he went to appeal to the High Court. And here is where it gets interesting. Before I get into that, I want you to understand something. Whenever you want to sue someone for, let's say, breach of contract, these are usually categorized under civil cases, and you don't just walk up in court and talk to the judge or the magistrate directly. You communicate with the court and with your opponent using documents. So in this case, if you're the one who's going to the court and telling the court that this person did 1, 2, 3, you're supposed to prepare a document called a plaint, which has the whole story from the beginning to the end. The opponent is supposed to reply that document with a document called written statement of defense. So he's going to defend himself. So it's going to be like that back and forth. And all these documents are recorded in court, they're kept in court, and they're also taken as evidence. So the magistrate or the judge can go back to what you guys said so that he or she can understand where you guys are coming from and so forth. So when Anselim went to the High Court, the judge looked at those documents. He looked at the plaint and the written statement of defense. And he found that David, the one who pushed Anselim out of the business, did not deny that there was an agreement. He never denied the key facts. He did not deny that there was an oral agreement, that it ever existed. He did not deny that his partner had contributed beer bottles, empty beer bottles or empty crates or any assets that Anselim said that he contributed. And in law, when you fail to deny a fact that has been put to you, that silence is treated as an admission that, okay, since you did not deny it, then you accept it. So the appeal was decided in favor of Anselim, and the court awarded him with everything that he asked, the compensation, and that his assets get returned to him and so forth. He won the case. But I want you to sit with how he won. He did not win because he had a contract. He did not win because he had witnesses who went to court and said, yes, we were there when they were making this agreement. There is, in fact, an agreement. No. He won because the other person accidentally accepted facts by not denying them. His outcome depended entirely on the partner's mistake and not anything he had done to protect himself. That is not protection, that is pure luck. And you deserve better than luck. Because what if that person had denied everything? What if he had a lawyer that knew exactly what to dispute and exactly what not to say or what to say? The case would have ended very differently. And the person who had built something, trusted someone, contributed assets to the business would have walked away with nothing. And he would have walked away with nothing not because the law wouldn't have protected him, but he wouldn't have anything to prove that that agreement existed. A written agreement changes everything, and it doesn't mean that you don't trust the person that you're starting that business with or entering into that agreement with, but because it means that what you and that person agreed is no longer a matter of memory or convenience. It's on paper, it is signed, and it is very clear. And before you tell me you don't even know where to start, you don't even know what to put in an agreement like that, that is exactly what I'm here for. I'm Scholastica Madundo, an advocate and legal consultant focusing on commercial transactions, and I work with people who want to make a move and want to make sure that they're covered before they do, not after. If you're about to go into business with someone, if you're about to pool resources with a partner, a friend, or a relative, if you have an idea and someone to build it with, and you haven't yet sat down to formalize what you both agreed to, before you do that, come and talk to me before you do. The link to my WhatsApp is put down in the description box. It will take you straight to my chat. You're welcome. Just come in and tell me what you want to do, and then we'll take it from there. Do not wait for something to go wrong to find out where you stand. Find out now while you still have every option available to you. Well, with that, I will see you on the next video. Bye.